Good afternoon, everyone. I'm coming to you live today on Facebook and YouTube from Samfiru, Tumarkin, Vancouver. My name is Darren Sall. I'm your employment lawyer for today for the next 30 minutes or so. I'm an associate in the Vancouver office. I do also handle files in Alberta. We are Canada's most positively reviewed employment firm. We are active in multiple provinces. We have offices in Alberta, BC, Ontario. And this is your chance to get on with an employment lawyer today. I also handle long-term disability work. And I'm here for the next 30 minutes to answer any of your questions. There's no questions too big, too small. We sometimes require additional information, and we'll give you the contact details as well as some resources on our website for you to go through to have any questions answered that you might want to have answered. I will try to get to everyone's question today. And so just some housekeeping for people who are in Ontario. You're more than welcome to ask your questions here, but we do have an Ontario session coming up on Monday, October 5th. That is with Lior Samfiru at 1 p.m. Eastern time. And Lior will be there. Sorry, Wednesday, October 5th. Apologies. It didn't sound right. And Lior Samfiru himself will be there to answer any employment questions that you might have. And you've got me for the next 30 minutes today. Before we start, I always want to direct people to, if you find these sessions useful, helpful, please like them on YouTube, LinkedIn, or Facebook, and you'll get updates as to when these live streams are occurring. We have multiple ones a week in both employment and disability law. And you can also subscribe to them, and you'll get notifications as to when the next ones are coming up. If you just want to listen in and just learn some information that may be relevant to your employment, or you want to actually dive in and ask some questions, go for it anytime. We're here to help. I'm here to answer your questions and to the best that I can. And we'll give you some resources as well. If you go to our website, we have pre-recorded shows. We have blogs that are updated weekly and monthly with new topics, hot topics in law, new case developments, changes in the law. So you can peruse through those at your leisure and see if anything might affect your employment, or maybe just answer a question you've had about past employment, current employment, or just stuff you've wondered about your employment rights. So before we get to some questions here, while we wait for a couple to filter through, I just want to figured I would talk about a couple topics. I know the vaccine topics have been hot over the last year and a half or so, and we've also had a recent wave of what we call group terminations, or companies being sold and purchased, which can lead to large swaths of employees being laid off or restructurings occurring. And so I wanted to talk a little generally about people's rights. And there's also work from home arrangements that have been a hot topic in my practice and in practices of my colleagues, as well as I'm sure many of you. So I think the work from home arrangements are the most interesting for me, and I think the most prevalent questions that I get from people calling in. And so one thing to understand is, with work from home arrangements during the pandemic, and with this hopefully winding down now, and some of those arrangements coming to a close, people have called in to ask, what are my rights? If my employer allowed me to work from home during the pandemic, prior to the pandemic, maybe for the 4 or 5 years or even 6 months prior to the pandemic, I had been working exclusively from the office. That's what my contract either says or didn't say, or that was the expectation or discussion. But during the pandemic, for obvious reasons, my employer allowed me to work from home. Can that be my permanent arrangement? Right? I've had some people even call in to say, hey, I've moved during the pandemic and I no longer live in the province or city that my employer operates in. Is that a problem? Can they force me to come back? Generally, if you're, and again, this is a general answer on that. I mean, we always want to look at the contract. If you have an employment contract, have any information or any discussions you might have had with your employer, those will kind of guide. But generally speaking, if you were in an in-office situation to start, and your employer allowed you to work from home during the pandemic, and it was understood that that was due to the pandemic, so a temporary situation, and there was no discussion on what would happen after, your employer does have the ability to control where you work from, and they can request you to come back in the office and require it. And if you don't, they can terminate you. For the example of where someone had moved provinces or cities, that actually had happened, and really it goes to what occurred prior to that. Did you inform your employer? Did your employer agree? So if an employer agreed that, yes, you're working remotely, we'll let you move to, from BC to Alberta to work, and we're fine to keep you remote. Well, then you can say, well, you can't require me to come back in the office, and you can't terminate me for that reason, on a for-cause basis. In BC and Alberta and in Canada, you can terminate anyone for any reason as long as it's not a discriminatory or protected reason under the Human Rights Code or similar legislation. You can terminate them on a without cause basis. You just have to pay them severance. And if you don't, it becomes an illegal termination, and you have the ability to sue for severance. So that's really what it comes to here. If your employer says, hey, I know you work remotely, and that's fine, but that doesn't work for us anymore, and we want you to come back, and if you can't come back, we're just going to pay you your severance and go our separate ways. There's really not a whole lot you can do unless they provided some kind of assurances. And that would be very fact specific. If they provided assurances that you'd be able to continue to work there for years to come or something like that, give us a call. Reach out to someone at our firm. We're more than happy to talk to you. There are very fact specific scenarios where we may be able to do something for you to grant you, give you additional rights or fight for additional rights for you. So always reach out. Okay. Looks like we have a number of questions that have come through. So we have off YouTube. Stick with it. It's always good advice. Stick with it TV asks, does it help or hurt my case if my attorney has already dealt with the other side's attorney and settled other lawsuits in the past against him or her? So stick with it. That's a very good question. And I think a lot of that really depends on it depends on your attorney. I always say relationships with the other side, generally don't hurt you. You have an understanding of how the other side operates. For example, if they entertain reasonable settlement offers, or if they do not, if their advice is usually, to tell their clients that, make them sue me in order to show you're serious or something like that. I think if one attorney's already settled files or gone to trial with another attorney, that's always helpful. You've got a relationship there. You've got lines of communication that are open. You hopefully have a measure of trust, and I think that can only help both of your cases, and help the situation come to an amicable and profitable and reasonable resolution. I think that's generally a good thing. I try to develop relationships with other attorneys all the time because you can only help your clients at the end of the day. So we have another question from Facebook from Sharmila. Sharmila asks, my employment contract states that I cannot treat any changes to my job as a constructive dismissal. Does this mean they can make whatever changes they want? So Sharmila, generally this allows your employer to make changes to your job, and if they make these changes. So for example, if they change your working hours slightly, or if they add or remove responsibilities from you, then generally a clause like this in your employment contract will prevent you from taking smaller changes from being a constructive dismissal of your employment. You've impliedly agreed that you've given your employer the ability to make reasonable business changes. So reasonable changes to your employment that fit the needs of the business. I would say if you get into a situation where, like with any kind of rule or general rule, there are always exceptions. So I think if you have an employer that, for example, you work 7 to 2 every day, and you need to do that, and that's very clear because of your family situation or whatnot. And then they say all of a sudden, hey, we need you to work from 6 p.m. until 2 a.m. So, the exact opposite shift when you maybe have to take care of a child as like a single parent or something like that. Something like that, you may not have a severance claim if you say, well, I can't do that. But if they've made this change explicitly to you only, knowing that you have a family situation that they have a reasonable duty to accommodate, you may have a human rights claim. And so where you may not be able to pick up or have a claim on one hand, you may be able to have it on another hand. So it's fact specific as to what kind of changes are being put to you and how that works. But I always tell people, when you have a situation like that, even if your contract says something that, for example, like this, says, well, if we make changes to your employment, you can't take it as a constructive dismissal. It never hurts to give us a call. We do free consultations. It never hurts to call in and to send us your contract and to say, hey, listen, this is a term here. This seems kind of weird to me. This is what my employer is trying to do. Do I have a claim? What's my recourse? It doesn't cost you anything to call and get a quick review and opinion on that. And it could, save your employment. Sometimes there are clauses in contracts that are not legal, and your employer may not even know that. They may just think, if we write this into contract, it's good to go. And that's not always the case. So I would say you're not going to lose anything by calling in and by sending us that information. So Sharmila, I know it's kind of a roundabout answer to your question, but really we need more details on the changes and whatnot. So I would invite you to call in. It'd be a lot more of a detailed and specific analysis that we'd require. So I would say call in, send us your contract, let's have a chat. Okay, and so we have quite a few more questions here. Paulo Brazil asks on Facebook, if my doctor has recommended to WSIB and or Manulife, I should be off work for psychotraumatic disability, and they don't agree with my doctor in regards to suitable work, can I be fired? So Paulo, I'm assuming that you are currently on long-term disability, and it really depends on a few things. So like I said, your employer can terminate you for any reason. They cannot terminate you for a protected ground. A physical or psychological disability would be a protected ground under, since you're referencing WSIB, I'm assuming you're probably talking about Alberta, could be talking about Ontario, but that would be a protected ground. So you would have recourse under human rights legislation, excuse me, if that was the case. The time you've been off work or the time you're expected to be off work is also a very important consideration. For example, if you've been off work for 6 or 8 years on disability, your employer may have grounds for terminating you on the basis of frustration of contract. So again, there's an answer here where you may have civil rights, but you definitely will have human rights, protected rights. But there's also counter arguments. So I would say give us a call. I'm happy to speak with you if you're operating in BC or Alberta, or call our firm 1-855-821. You can see it at the corner there, 5900. And you can ask to speak to someone in Ontario as well, or any other lawyer who operates in any of the jurisdictions in which you're living. And we're more than happy to give you a hand. Okay, and we have a question. So Paolo, I hope that answered your question to a certain degree, and I do encourage you to call in to give us a little more detail. So we have a question through YouTube. It's from JX2, and JX asks, did the grocery worker who got fired for giving away the discarded food ever get their case resolved? So it's a great question, JX. We can't really comment on current or ongoing cases. I'm not involved in that, so I can't really say one way or another. But I appreciate you following the claims that we're bringing. That's nice to see. And so Julia has a question off YouTube. Julia says, if I have an annual salary bonus in my contract, can my employer decide not to pay that if sales are down? So Julia, that's a great question. And that really depends on the wording of the bonus, on what basis it's granted. If the bonus is based purely on performance, and there's, say, key performance indicators or KPIs that you have to hit in order to receive the bonus. For example, typical wording could be along the lines of, if you're in sales, okay, and it says you have to sell X number of dollars in quarter one, X number in quarter two, quarter three, quarter four, the same. And if you do that, you get an annual bonus of 20% of your income. something along those lines. If you hit those key performance indicators in the contract and you've met those requirements, you are owed that bonus at the end. If the bonus calculation says your entitlement to the bonus is tied directly to company performance, and if company performance is below a certain level, below 40% profit, no bonus will be paid. As long as they're below that amount, then the bonus would not be paid. So it really does depend on the wording of the contract, the wording of the bonus provision. I would say give us a call, send in your contracts. We can actually take a look at that provision, and we can go from there. If your salary bonus is simply based on you being there at the end of the year, if it's simply that at the end of each 12-month period, you'll be awarded a bonus of $10,000, provided you stay with the company, or you stayed with the company and worked X number of hours or something like that, and there's no stipulations on the amount of sales required, then you'd be owed that. That would be my view, is that you'd be owed that bonus. If there's no tying to sales or whatnot, I mean, it's a business decision on their part, I guess, and they could simply terminate you in that case. So I think the best thing to do would be to grab your contract, send it in to us, have a chat, and we can figure out what your rights really look like based on the wording of that contract. So hopefully that answers your question, Julia. We have Roberta has a question on Facebook. Roberta asks, I have been on LTD for 6 months and I have the case manager working with my employer for my return. Okay, so I'll just stop there for a second. And that's fairly typical in any kind of long-term disability claim, that the case manager for the insurer, their goal is to try to get you off disability. So it's to try to get you back to work as soon as you can, with accommodations that are required, if any, and if not, then just to get you back to work full time, because then they can take you off their policy and stop paying you. And so typically they will work with your employer during this period to try to get you back, to try to see in what way they could support you, either with physical aids, or what type of accommodations they can recommend or assist the employer with implementing to allow you to come back to work and to get you off the disability policy. So Roberta continues to go on with, beginning of August, my employer agreed to a gradual return. However, after I requested a detailed job description, they changed their mind and said I needed to return full-time, as this was required to fulfill my manager duties. I was advised by a previous manager that my employer promoted 2 supervisors to cover for me, and my position no longer exists. I'm still waiting for a response from my employer regarding what my position will include. So, Roberta, you've done the right thing here. Not only coming on to ask questions, but also to asking your employer for a detailed job description on what you'd be doing when you went back to work. The fact that they've promoted people to fill your position and that your position no longer exists fits on the employment side a bit, right? And so if they've promoted your position out of existence and you really have no position to come back to, then they need to put you back in a comparable position. So whether that is as a third manager, and if you had reports, you'd have to kind of look and make sure that your general job duties have stayed the same, your level, prestige, your reporting structure has stayed the same. If they're returning you to a new job that is obviously, for example, better than the one you had before, or a step up, more pay or something like that, then great, no problem there. But if they're bringing you back to a position that's obviously lower, then you definitely need to reach out to us, because that may rise to the level of a constructive dismissal, depending on the facts. This is also dependent on when you're going back to work. So again, timelines here are important. So if it's only been 6 months and they're saying, hey, we can't accommodate you coming back because of X, Y, or Z, your employer has a duty to accommodate. Okay, and that's accommodating you returning to work to the point of undue hardship. Now, undue hardship is an incredibly high bar. Simply saying that your manager duties can't be fulfilled, that's insufficient. So again, you've done the right thing by saying, well, what's the job description? What on here can't I do? And if they can't really point to anything and they're just refusing to bring you back, well, there may be issues between your employer and your insurer, and we just don't want you to get lost in limbo. If they're refusing to bring you back and the insurer says, well, fine, if they won't bring you back, we'll keep you on long-term disability until you can go back fully. Then fine, no problem for you. Okay, now if they're saying that we can't bring you back, and the insurer is saying, well, too bad, you can work, right? You can work, we're not going to continue paying you, then we've got a problem. And then you've got a problem that you need to deal with. And I think at that point you need to reach out and you need to talk with us, because depending on the situation, specifically what each party is saying, we'd have to determine the best way to help you move your claim forward against either the insurer or your employer. And that again really depends on the medical evidence and for example, whether or not you are actually coming out of your disability, whether you're able to work or you're going to be able to work, or whether that disability will be persisting. And so I would encourage you, Roberta, reach out with both your employment contract and your LTD benefits contract of coverage, and then we would be able to book you in for an appointment and really dig into this and give you some tailored advice. Okay, we got more time here. So let's see, from YouTube, we have a question from TPNE Ryan. And TPNE asks, I requested for COVID pay because I qualified for it back in early September and I've yet to receive that. What should I do? Yes, I'm not quite, TPNE, I'm not quite sure. That wouldn't really be from us. You would have to speak to, I'm assuming you're talking about CERB or CRB. So you'd have to speak to Service Canada about that. We don't really deal with anything like that. If there's some kind of COVID pay that you're receiving from your employer, I think I need more details before I'd be able to answer anything about that. Sorry. Okay, let's see. We have Tammy from Facebook coming in. Tammy asks, I was laid off from my position and not brought back. My employer instead filled my position through an immigration program. What can I do? Okay, so Tammy, depending on how long you were laid off, and so I'll speak with respect to BC right now, and Alberta, and well, generally Ontario as well, but I'll speak with specificity to BC at this point. And so if you were laid off, and there's, you can take that as a constructive dismissal of your employment if you did not agree to the layoff at the time that it happened. Voice your objection, in writing generally is always the best and most advised course of actions. To, if you don't agree with something, you object in writing. It preserves your right to pursue something at a later date. If your employers filled your position, so in British Columbia, for example, there are layoff guidelines in the Employment Standards Act. And as long as you're in an industry or field that the Employment Standards Act is applicable to, there is certain exceptions. As long as you're in a field that it's applicable to, after a certain period of time, for example, 16 weeks in any 20-week period that you're laid off for, you're deemed terminated by operation of law. And so if you've passed this period, so Tammy, let's just say you were laid off March 2020 because of COVID, when a lot of people were. By now, if your employer hadn't received numerous variances to extend the layoff period, your employment would likely be terminated by operation of law, and you're entitled to pursue severance. And especially so, it seems like if they've already filled your position, whether through an immigration program or otherwise, but if your position's been filled, and there's not actually a position to bring you back to, it's just all the more clear that I think your employment has been terminated. It'd be interesting to see what, if you've had any communications with your employer and maybe what they've said. But if not, really, then your options are to pursue severance at this point. And if that's the case, I encourage you, again, reach out, send us your employment contract if you have one. And we can talk to you about your rights and your entitlements. And so Roberta's come back in. And so Roberta, I think you've got two or three follow-ups here. I think the insurance company is asking my therapist if I'm able to work. I know my case manager has reached out to my therapist to confirm if I'm fit to return, so I may have more questions. Yeah, Roberta, I think there's quite a bit of detail here we'd have to kind of dig into. So again, give our firm a call. If you're in BC or Alberta, I'm happy to speak with you, or just give the firm a call. They'll connect you with somebody. we'll be able to give you some assistance. If you're in Ontario, connect, and again, they'll hook you up with somebody who will be able to help you. The insurance company reaching out to your treatment providers to determine your level of fitness or whether you're fit to return or able to return is not unusual. But I think we need a little bit more of the background information to determine whether or not this is reasonable at this stage. And I think that's part and parcel for you to discuss with your therapist as well. Okay, and we have Alana with a question on Facebook. Alana asks, I worked for my company for 23 years. 18 months ago, they brought in a new manager who I filed a harassment claim against because of his conduct. I was suspended without pay after this, and my complaint was not looked into. Is there anything that can be done about this? So yes, Alana, there is. So if you are, you've got a human rights complaint, potentially, you definitely have a WorkSafe complaint. So I would suggest you contact WorkSafe immediately. There are certain deadlines in which you must report a claim. In this case, you've got both a claim for harassment that you should report to WCB, and you've also got a potential prohibited action. And what a prohibited action is when you make a complaint for something like bullying and harassment, or filing a grievance or complaint for health and safety violations by your company, and your company takes a punitive step against you, such as terminating you, or in this case, potentially putting you on an unpaid leave or suspended without pay. I'm not sure how long ago all this occurred with the harassment and the unpaid leave and the complaint, but if you've made a complaint, your employer also has a duty to investigate this. And if there's an improper investigation, that can also lead to consequences. So Alana, I would say reach out to us. There's also civil options as well for you to pursue in a civil claim against your company. So I would say, Alana, reach out to us. Again, employment contract, if you've got one of those, this goes for everybody. If you've got one of those, send them in, because it is so important for us to be able to provide you with that appropriate and tailored advice, to review your contract, to give you a full explanation of your rights. That is very, very key. So Lana, reach out, but I would say definitely you can contact WCB and also Workers' Compensation, WorkSafe BC, and lodge a complaint with them. And I would do that sooner than later, based on, because there are timelines that will bar you from making a complaint after a certain date. Okay, and we have JX2 off YouTube, and it's asking, if an employer generally pays by direct deposit, are they still required to give you a check if you request it, or are you forced to get a bank account? So it's an interesting question. I haven't really had that come up too often. Generally, I would say you're probably restricted to the employer's payment practices. If you request a check, and they're going to incur another fee, they may not want to do that. But again, they can't force you to get a bank account. And I imagine that if that was going to be a huge issue, they may just issue you the check. So I think that's something that you would have to just kind of take up with your employer. At the end of the day, if you're owed money for work you've done, you've got to find a way to get paid, and they've got to find a way to pay you. So I would just kind of suggest trying to work that out with the employer. Direct deposit may not be an issue, or it may not be an option. Checks would be, they could make out a check to cash, for example, or give you a money order or something like that. So there's probably some options that could be worked out. That could be worked out if you don't have a bank account. And we have time for maybe one more question here from Belinda. Do I have to tell my employer if I'm working from a different location than my home if I work remotely, like if I go to a cottage? So, Belinda, this is actually quite a detailed question. There's a lot of stuff to hit here, but the quick answer would be, if you have remote working privileges and they're specific to your home, if there's firewalls or security data stuff, for example, you may run into issues if you try to work from different locations. It may also breach IT policies. So it would depend on if you have an IT policy and the content of that policy, as well as your contract. So I would always advise just speaking to your employer. The last thing you want to do is, if you have a question about something, doing it anyways, and then finding out you've breached a policy, which could, disentitle you to severance in some situations. So we have run out of time today. I think I managed to get to almost everyone's questions. Join me back in 2 weeks. Like today's session if you enjoyed it and found it useful and helpful. Subscribe. I'm back usually every 2 weeks. Plenty of my colleagues are on in the interim as well in BC, Alberta, and Ontario. And Wednesday, October 5th, we have the Samfiru Eastern Time, 1 p.m., who will be on to answer all of your employment questions relevant Canada-wide. Thank you for joining me today, and I wish you all the best. Thank you.